judgment in the matter of the Queen on the application of Wright versus Resilient Energy Severndale Ltd and Forest of Dean District Council.
In July of this year, the Supreme Court went to spend a week sitting in Wales for the very first time. It hopes it'll be the first time of many into the future. And during that week, we heard 3 cases. We gave judgment in one of them a little while ago, and today we're giving judgment in the remaining 2. So the first of those is the case of Wright, and Lord Sales will explain the decision of the court.
This case is concerned with the law relating to planning. The issue which arises is the relationship between the statutory planning regime and statements of policy by central government. The first appellant, Resilient, applied to the Forest of Dean District Council for the grant of planning permission for the change of use of land at a farm in Gloucestershire from agriculture to the erection of a wind turbine. Central government has issued policy guidance to encourage community-led wind turbine developments, including by finding ways in which the economic benefits from such developments can be shared in the local community. Resilience Development Scheme sought to rely on this policy guidance and included proposals for the wind turbine to be built and run by a community benefit society and for annual donations to be made to a local community fund out of the operating profits from the wind turbine for distribution to local good causes. The council decided to grant planning permission for the erection of the wind turbine. In doing so, they explicitly relied on the proposed annual donations as a relevant factor in favour of the grant of permission. The council made it a condition of the scheme that the annual donations should be made. The appellant, Mr. Wright, who owns land in the vicinity, commenced these proceedings to challenge the grant of planning permission. His argument is that the council went wrong in law in treating the annual donations as a relevant factor in favour of the grant of planning permission. Mr. Wright succeeded on that argument before Mr. Justice Dove at first instance and in the Court of Appeal. Resilient and the Council appealed to this court. The Secretary of State for Housing, Communities and Local Government was given permission to intervene on the appeal as well and has made submissions in support of Resilient and the Council. The issue which arises is whether the annual donations under Resilience Development Scheme qualify as a material consideration in the language of the relevant planning statutes. That is the phrase used in Section 70 of the Town and Country Planning Act 1990 and in Section 38 of the Planning and Compulsory Purchase Act 2004. There is a considerable body of case law which deals with the proper interpretation of that statutory phrase. On this appeal, the court has traced through the case law, which all parties agreed provided the relevant guidance regarding the interpretation of the statutes. The case law emphasises that it is a fundamental principle of the planning system that planning permission cannot be bought or sold. This principle serves to protect both landowners and the public interest. It prevents a planning authority from extracting money or other benefits unrelated to the proposed use of the land as a condition for granting planning permission. It also prevents a planning authority from deciding to grant permission by reference to other matters than by reference to the planning merits of the proposed development in issue. This principle is derived from the threefold test for material considerations and lawful conditions relating to them, which was laid down by the House of Lords in the Newbery District Council case in 1981, and which has been applied ever since. According to the Newbery test, something will only qualify as a material consideration within the meaning of the statute if, first, a condition relating to it is imposed for a planning purpose and not for any ulterior purpose. Second, it fairly and reasonably relates to the proposed development of the land in question. And third, it must not be so unreasonable that no reasonable planning authority could have imposed a condition in relation to it. This court holds that Mr. Justice Dove and the Court of Appeal correctly interpreted and applied the planning statutes. The appeal is therefore dismissed. The community benefits promised by Resilient did not satisfy the Newbery criteria and therefore did not qualify as a material consideration under either the 1990 or the 2004 Act. The benefits were not proposed to pursue a proper planning purpose, but rather were put forward for the ulterior purpose of providing general benefits to the community. Also, they did not fairly and reasonably relate to the development for which permission was sought. The community benefits did not affect the use of the land, but were instead proffered as a general inducement to the council to grant planning permission in breach of the principle that planning permission cannot be bought or sold. The statutory concept of a material consideration, as interpreted by the courts, does not vary according to government guidance and policy statements. The protection against the buying and selling of planning permission has been established by Parliament through statute. It cannot be overridden by general policies laid down by central government. In any event, the central government policy relied on in this case explicitly recognises that the grant of planning permission for wind turbine developments must comply with the relevant statutory planning regime.